Namaste, I am Ayush Mahanti welcoming you all to this video. In this video, we will discuss about an important concept, twofold test for minority institutions. Now, without any delay, let's start our video. On November 8, 2024, Supreme Court of India, in its 4:3 ruling, laid down a twofold testing for determining minority status of educational institutions in the Aligarh Muslim University versus Naresh Agrawal and others case. The Supreme Court overruled its judgment in S. Aziz Vasa versus Union of India 1967, which held that Aligarh Muslim University was not a minority institution under Article 31 of Indian Constitution. However, the minority status of Aligarh Muslim University will be determined by 3 judges bench of the Apex Court based on the principle evolved in this judgment. Now we will see about Article 30 of Indian Constitution. What does it say? Rights of minorities to establish and administer educational institutions. Now focus on these two words, establish and administer. Clause 1 of this article says that all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority, referred to in clause 1, the state shall ensure that amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. Under that clause means clause 1. The state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Now there are some core features of minority institutions. Under Article 30, Clause 1 of the Constitution of India, the core feature of the minority institutions are: while the purpose of establishing a minority institution should be the conservation of language and culture, it need not be the only purpose. A minority institution will not lose its minority character by admitting students belonging to non-community. Secular education can be imparted at a minority institution without affecting its minority character. Listen carefully. If a minority institution has received aid from the government, no student can be forced to participate in religious instruction, and if the institution is fully maintained out of state funds, it cannot provide religious instruction. However, these institutions must still be considered as minority institutions. Now let's focus on twofold test. In my third slide, I had said to focus on two words, establish and administer. Let's see what are they. Establishment means what? Origin of the idea for establishing the institution must be linked towards a person or a group from the minority community. The purpose for establishing such minority institutions must be predominantly for the welfare of the minority community. Listen carefully. The court must also look into how the idea was implemented, such as donors, persons who obtained the permissions or handled the construction of the institutions, etc. Second, administration. If the administration does not seem to protect and promote the interest of the minority, it could be reasonably inferred that the purpose was not to establish an educational institutions for the benefit of the minority community. For the institutions established before the constitution came into force, the court must also look at how the administration worked on the date of commencement of the Constitution of India and whether any regulatory measures were adopted to take control from the founders. Now we will see about the backgrounds of legal dispute of Aligarh Muslim University. Listen carefully. Sir Syed Ahmad Khan founded the Mohammedan Anglo-Oriented College in Aligarh in 1875 to promote Western education among Muslims. Aligarh Muslim Universities Act 1920 integrated all the colleges and institutions established by Sir Syed Ahmad Khan into a single university. And as per section 23 of this act, only Muslims could be part of the university's governing body, which was University Court. Now, amendment of this act in 1951 allowed non-Muslims to be part of the University Court, which was the governing body of the university. And in 1965, another amendment to this act divested the status of University Court and made AMU's Executive Council a supreme governing body. And these two amendments were challenged in the apex court. In S. Aziz Vasa versus Union of India 1967 case, about this case we had discussed in our second slide, okay? The Supreme Court ruled that Aligarh Muslim University was neither established nor administered by Muslim minority. Rather, it came into existence through an act of central legislature. In 1981, the Parliament amended the AMU Act 1920 and stated that it was established by Muslim community to promote the cultural and educational advancement of Muslims in India, which effectively restored its minority status. In 2005, the university reserved 50% of seats in its PG medical courses for Muslim students. In January 2006, Allahabad High Court struck down this provision and the 1981 amendment of AMU Act 1920. In 2006, a two-judge bench of the Supreme Court stayed the reservation policy of AMU, referring this case to a larger bench, and in 2019, this matter was referred to a seven-judge bench of the Supreme Court. And in our second slide, in the third point, we can see the decision of the Supreme Court. The minority status of Aligarh Muslim University will be determined by the three judges bench of the apex court based on the principle evolved in this judgment. Now, I hope you understood this concept. In our next video, we will discuss about some new concept. Thank you.